Director Helpman,
Present.
Director Origi,
Here.
Director Hawkins,
Here.
Director Ustui,
Here.
Director Vasquez,
Present.
Director Camacho Rodriguez,
Present.
President Apodaca.
Present. Invocation, Director Hawkins, Pledge of Allegiance, Director Rodriguez.
Please bow your heads. Our Heavenly Father, we want to thank you for allowing us to meet like this on a regular basis. Please bless everyone that has shown up today and all those that could not show up for some physical or medical reason. Please bless each one of them. Please watch over us as we conduct the business of the day. Give us the knowledge and the courage that we may need. And in Jesus' name we pray. Amen.
Amen.
Pledge of your heart. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Do we have a certification?
The agenda is posted.
And of course, before I say public comments and presentations,
No
I'd like
public
to welcome Mike Sprague, who I've known 21 years. Here we are. Okay.
No public comment cards
No
been
comment,
received.
okay. Item 3, resolution of the Board of Directors of the Central Basin Water District establishing a short-term retail meter charge with a sunset provision.
Yes. I believe Director Skewy, as chair of the committee, was going to... Mr. Chair, to go through the resolution.
Please.
Mr. Chair, thank you very much for the opportunity to go through the resolution. And it's best probably to set up the framework for why we are here looking at this resolution today. I think this is a third attempt in trying to establish a rate, a fixed rate, meter rate charge. We started this process back in May. When we discussed initially the issue, we heard a lot of comments from the purveyor community. This board understood the fact that we needed to have a dialogue, continue a conversation with the purveyor community to understand their challenges that they have to go through when an additional charge is something that they have to absorb that is not necessarily predicted in their budgets. And the timing, I have to admit, was a bit off because right around May and June is exactly the same time that the cities adopt their budgets. So this was, in essence, an unforeseen expenditure for them. As a result of that, there were communications between the district staff and some members of the board with the purveyor community to again understand the constraints that they have to face and to frankly find a common ground based on some mutual understanding to explain the position that the district has been, the financial difficulties that we have been exposed to, particularly in the course of the last year and a half, and quite frankly, to be able to avoid litigation, because that was the premise. You know, when we first heard from the purveyors, it was with a premise and the talk of litigation, and who needs that? Purveyors don't need that, the district doesn't need that. So in the spirit of cooperation and trying to find a solution to the issue, there was the framework of a resolution that you see before you that was drafted. I think it addresses the district needs and it also satisfies the purveyor community to the point that based on certain provisions in this resolution, we would be able to continue the work that this board is going to be doing with the purveyor community to hopefully find a solution, a long-term solution to address the structural deficit that the district has had in the past and will continue to have if there is no action. One of the provisions, the most important one, is that this is not a fixed charge, or a meter charge rather, a retail meter charge that is going to be imposed forever. There is a sunset provision of 3 years. The essence of that is that the district and the purveyors are going to work out to find out, again, some solutions to the long-term, to structure a long-term stability, financial stability for the district. There is a subcommittee that has been formed by the board. The subcommittee is going to be working with certain representatives of the purveyor community for the next 6 months diligently, and the product of that is going to be some ideas and some concepts that, again, hopefully is going to address the structural deficit and we won't be having to confront in the future. There are certain other provisions in here, and because there have been some questions and ambiguities in the past, if you allow me, I'm just going to go through it without having to go through the whereases. The important part of the resolution is now therefore be it resolved portion, and it starts with Section A, the 2019-20 fiscal year budget adopted. A1 states that the budget, the 2019-20 fiscal year budget was adopted on July 10th of 2019 with certain reduction of expenses, and we know the detail of the expenses. If there is any particular issue, I think Andrew will be able to address that. It was to the tune of $278,000. How much was that, Andrew? The reductions at the end of the day? Plus the, yeah.
Are you talking about on the July 10th meeting?
Yes.
There was a increase in potable volumes, resulting in an increase in sales, potable sales of $238,000, and then a revision to the expense of lowering $78,000, the cuts the board approved. Those are the two.
The total cuts that the board approved? The total cuts since the beginning of the budget?
For that day or for?
Total, for the year.
The total cuts were the $350 for staff plus the $78. Those are permanent cuts. And if you look at the total overall cuts that were made to the budget for the fiscal year, there's some proration of the permanent cuts, some additional expenses. You'll see that in a memo that we're writing. It's approximately $400,000 was the total expense cuts. I hope that answers your question.
Excuse me, Andrew. Do we have that paper that you're making reference to? Do we have that here on the dais?
I have a copy if...
May I have one? A
Sure.
copy?
And that was a budget that was adopted, right?
Yes, but we are bringing this to the committee in August in case...
Right.
But just to explain, the budget process each year is an iterative process where the board and the public has input. From our original budget, when we started out and requesting a fixed charge of $468, there was a series of actions, either board cuts or increased revenue, for example, the LIBOR and the increased potable sales, and 2 rounds of cuts, and that's how we went from the $468, I think it was $240 rate, down to the $2 even and $190 rate for the water. So, but we have a chart with that. Jack. That's that straight. Much Rodriguez.
Section A2 states that further reductions, and that's going to be part of what we are going to be discussing with the purveyors representatives in the next 6 months, which states that further budget cuts shall be enacted in the current and subsequent years as a means of further reducing costs in accordance with Section E below. Now, given the fact that we've already adopted the budget with certain cuts, really what this section should say is that shall be enacted in subsequent years, because again, the budget for this year is already in place, so the cuts that we have to make is going to apply to the future years. Section B, water rate increase to be offset. B1 states consultation, and that's what I was referring to, the work that is going to be happening between the district and district reps and reps from the Purveyor community. District staff is instructed to meet and confer with the ad hoc committee on fiscal sustainability created below prior to initiating or recommending subsequent increases to the imported water rate in excess of 10% over the new rate established herein for such imported water provided in any subsequent fiscal year. Then it states staff is instructed not to seek future rate increases in excess of the amount except concurrently with a plan to be adopted by the board to further reduce the budget for that fiscal year by at least 10% as compared to the immediately preceding fiscal year. Again, the intent in here is to be disciplined, keep with the premise that we are not going to increase the operational cost beyond the point that you have to go back and ask the ratepayers to pay more. So the threshold has been set in here. And what are the retail meter charges? Section C states that the meter charge established to be imposed annually by the district on each member purveyor that has within its boundaries at least one retail water meter capable of serving water to retail customers within the boundaries of the district based upon the total number of such retail water meters served by the member which are in service as of January 1 of the applicable year. It sets the rate. There is a rate cap for the life of this, the 3 years. The retail meter charge shall not exceed $2 annually per retail water meter. And this was a special request by the purveyor community that they needed to have some sort of an assurances that there are not going to be creeping, and that's my vocabulary, creeping rate increases in the future. And there's, of course, the sunset provision, which is set at June 30, 2022, 3 years from now.
Director, there had been a request for definitions of some of those terms, and there's a paper, I believe, at every director's desk with definition of tolling, sunset, and rate cap. But if anybody had a question about what those terms mean, that's prepared by the attorney.
So if there are any questions from the audience about any of the definitions, I'll be happy to go through this, but the definitions that we have in front of us prescribes and describes what is tolling, what is a sunset, and what is a rate cap. I don't think it addresses the difference between tolling and there is a, well, I'll get to it when I see it, but let me just go through it. The next section has to do with the ad hoc member committee on fiscal sustainability. The Fiscal Sustainability Committee, it's a working group, the ad hoc committee on fiscal sustainability. From here on, it's going to be called CFS. Chaired by the district, is hereby establishing, representing the district and the purveyors to review and evaluate the financial condition of the district. The committee shall review the obligation of the district over the coming 5 fiscal years and available revenue sources within the purpose of developing a sustainable budget plan. Sustainable budget plan from hereafter in this document is referred to as Fiscal Sustainability Program or simply the program. For presentation to the board for approval within 6 months after it starts its work, and which can thereafter be revised as necessary to achieve fiscal sustainability. The committee's primary goal shall be to determine prudent means by which the district will be able to fund needed services, reduce expenses, and consistently operate with a balanced budget without the need for a continuation of the retail meter charge. And that's the ultimate goal of having a sunset, such as the one that we are putting in place. The program shall include sufficient cost reductions to result in a balanced budget given anticipated increasing debt expenses and may include any legal and sustainable revenue sources. District reps are myself and Director Hellman and 2 elected directors, Directors Hawkins and Camacho Rodriguez. The board president shall select a chair. Member representatives from the purveyor community shall be those selected by the city of Lakewood, Signal Hill, Paramount, and Norwalk, representing the municipalities. One member selected from the mutual water companies, and one selected by the Central Basin Water Association, representing the purveyors. Parcel tax. This is one of the avenues that the district is going to pursue in lieu of having a meter charge in the future. As you just heard, there are references in relation to the fiscal sustainability into the future to seek other means of revenue increases in the future. One of those that the district has contemplated in the past and will continue to contemplate and work on would be a parcel tax, potential parcel tax. And this document states that district is evaluating a plan for imposing a parcel tax, which can be a part of the program. Authority. The district retains its ultimate authority to adopt its own budget without approval by the Committee of the Purveyors. As I stated, the Committee of the Purveyors, in good faith, will negotiate with the district representatives to come up with a sustainable plan, financial plan. That's going to be a recommendation, and ultimately this board has to adopt it through a resolution, that particular program. This is an important part because essentially we are doing all of this in order to avoid litigation. But the caveat is the cities and the purveyors as a whole, they don't want to give up their right to pursue a lawsuit because they have some issues with regards particularly to the issue of the appropriateness of this particular meter charge. There's some questions about Proposition 26, and if under that proposition we can impose this fee or not. That's their right. They want to reserve the right essentially to be able, after the sunset provision, to sue the district if they continue to disagree. We hope that this agreement is going to dissipate in time, but they want to reserve their right, and the district has certain rights also to defend itself, and all of those are spelled out in the Section E, which is the tolling of claims. And because there were questions about that, I'll go through the definition that our legal counsel has provided. What this tolling means, essentially pauses or delays in the which a lawsuit must be brought. It can prevent the filing of a lawsuit by relieving the time pressure to file while the parties try to work out their differences. And that's exactly what we are trying to do in here. There are differences of opinion, particularly with as related to Proposition 26, which under that framework we are instituting this retail meter charge. And we are hoping that through the work of the committee, those questions are going to be addressed and answered, and there will be ultimately no need for unnecessary legal challenges and legal costs that comes with it. And obviously the sunset provision is another clause or provision that can be adopted as part of law and designates a point in time when that specific law will no longer be in effect, and that's the life of this resolution, essentially, the 3 years that I just mentioned. As stated in the recitals, there is a dispute between the district and the purveyors as to whether the retail meter charge is considered a tax under Proposition 26, such that the retail meter charge can be imposed without a vote of the people. Obviously, if it's considered to be a tax, then it has to be approved by the voters. But if it's a fee and not a tax, then it's an administrative process that we're going through right now. Due to the district's commitment herein to publicly develop a fiscal sustainability program, the purveyors have offered to allow the district to collect the retail meter charge up to the meter rate cap of the $2 without filing or otherwise initiating any legal challenge to its validity until June 30th, 2022, so long as the program is being implemented. Tolling of claims in exchange for the purveyor's offer and agreement described above, district agrees that any right to file or otherwise initiate a legal claim or challenge to the imposition of retail meter charge shall be tolled as provided in this resolution. The district hereby waives the right to assert any defenses of statute of limitations, latches, or similar provisions. Latches, to the best of my knowledge, is a legal term. It's a little bit different than the statute of limitation, if you want to go through that.
Sure, it's essentially just a judge-created doctrine. It's different than a statutory deadline to file a lawsuit where the judge can, under some circumstances, determine that because parties waited too long to bring their claims, the facts are sort of stale and they can no longer be litigated.
Thank you. Until June 30th, 2022, or until such earlier time as to any purveyor who gives written notice that it intends to take legal action, and the tolling shall continue for 30 days following such notification. And it goes through the rest of the legal terminology and the deadlines, and such as the 72 hours, Brown Act compliant, published and posted notice of at least 72 hours in writing of its intention to take such action by the district and so forth. Section 3 reads, additional understandings, this resolution is intended to act as a tolling agreement to facilitate resolution of the proceedings and disputes over the legality of the retail meter charge. This resolution and its contents shall not be treated as an admission by any party, and that's typically what happens in a tolling agreement. Purveyors do not forfeit any claims, and the district does not forfeit any claims or defenses by the adoption of this resolution, except for the tolling agreement set forth herein. Nothing in this resolution is intended to or shall be construed as waiving, impairing, or prejudicing the rights and interests of any party with respect to claims or defenses thereto as they existed on the effective date. The next section addresses claims. This resolution shall not preclude the application of any statute of limitations, limitation periods, statute of repose, or other similar time-related, equitable, contractual, or statutory defenses that may have existed prior to the effective date, nor shall this resolution have the effect of reviving any claim or cause of action that was borne by any such defense prior to the effective date, nor shall this resolution prejudice the rights of any party to urge such defenses. This resolution is intended to suspend the running of any applicable statutes of limitations or other similar time-related, equitable, contractual, or statutory defense during the tolling period with respect to the possible claims. That's why we pay our lawyers to draft language such as this one. Miscellaneous notices provided here under shall be given by first-class certified mail, and then the other administrative framework that is set in here. Amendments to this resolution may not be repealed or amended except upon a minimum of 30 days published and posted notice stating the board's intention to consider such action for obvious reasons. Again, we have to remind ourselves that this was done in the spirit of cooperation and primarily to avoid unnecessary lawsuits. We have heard the purveyors. We understand their concerns. We appreciate the fact that they formed essentially a coalition among themselves so that they could sit down with the district and find out a resolution to the problem. And we're going to be working hard with them in the future, especially in the next 6 months, to come up with that necessary framework to address the financial concerns of the district. I think this is a good solution. I think it is good for the district, and it's certainly good for our purveyors and the community that this district serves. Mr. President?
Do you want to read the motion?
Will there be any discussion on this item? I mean, that was the purpose of us having this meeting,
Of
right?
course, sure.
Yeah.
Sure, that's your
I mean, you're the chairman, so I want to make sure I follow protocol.
your question.
Okay. So, who drafted this resolution that we have before us on this agenda item? I'm asking the attorney. Were you involved with drafting this?
I was involved in editing it.
Okay. And who did we get the original version from?
The purveyors.
The purveyors, okay. And what, can you tell me what edits you were involved in making?
I don't remember them specifically, Director Vasquez, but I believe they were input into the resolution.
Okay. Was there any discussion about this board developing its own resolution that is in the interest of this agency among the attorneys? Was that?
Yes, with Mr. Smith, Attorney Smith and Attorney Pelham, we discussed whether it was the content, whether the format of the resolution was appropriate for us to implement or whether we needed to start from scratch. That was the thing, and we thought it would be better to just bring it this way. The board, it does have Gina's edits, it all together with Bill and Alfred's and other staff edits. It's not perfect, it's not what we would have drafted on our own, but this is a negotiation, and so it appears to be appropriately negotiated.
Okay.
The purpose
So-
of this meeting is for the board members to put their input into any changes that they'd like to see.
We have our law firm that we pay every month to provide a legal service to this agency. And we have requested an opinion on this particular issue. Is that something that has been produced by our attorneys?
I'm sorry, what opinion was requested? The agreement has been reviewed by the attorneys, edited by the attorneys. They've had discussions with the other side's counsel and done their appropriate jobs. I don't know what opinion is. Of the legality of it, yes.
Yeah. You just mentioned that this resolution was feedback from the purveyors and that we're having this meeting for the board to give feedback on this resolution. We have attorneys that we hire that are here to represent our position here and to ensure that whatever resolution is brought before us is in the best interest of this agency. And I'm asking for something that has been already requested. One is an opinion on this particular, not edits. And I would like to know what the edits were. At some point, I think that's very
We have a
important.
red line copy. I'll be glad to send you all the edits.
So I would like to get the edits, and I would also like to get an opinion from our firm in writing on the benefits and the drawbacks of this, the impacts of this particular tolling agreement on our agency.
Mr. Chair.
I'm asking is that a difficult question should I repeat that? I mean, we've already asked for this opinion several times and we haven't received it. And this is a very important issue for our agency. We have already been informed by a number of purveyors that we are going to be involved in litigation. And we have asked, I know I have been one of the directors that has asked for that opinion in writing, not in some closed session discussion where in the future when we say, well, the lawyer said this, they can say, no, we didn't, which is what happens very often in this agency. We're asking for a written opinion.
If you look on the specific part of it, if you look on the piece of paper which has the tolling sunset and rate, at the bottom it talks about the legal pros and cons. Most of this is a political, institutional thing, but on legal pros and cons, it's right at the bottom of that paper, May.
Can I add a comment to that?
Yes,
On
please.
page 3, where it's under tolling claims number 2, last sentence, the district hereby waives the right to assert any defense of statute of limitations, latches or similar provisions until June 30th, 2022. So for me, looking at that, I'm waiving rights. So I'm waiving Central Basin's rights, but waiving of rights from our counterparts that we're co-working with. So that's a concern to me, especially if we're looking at what would be the benefit and what would be maybe possibly a not good benefit to us. That is, for me, requesting in writing why this would be a good idea.
I can provide a quick summary of what this resolution, I believe, is intended to do and what it does. And if there's a further need for opinion, we can address it separately in writing. But this resolution acts in a way that's very similar to a traditional tolling agreement in that it takes the time pressure off of those who believe they have legal claims against the district to assert their claims, and thereby makes it possible for the parties, it can prevent a lawsuit by giving the parties an opportunity to try to resolve their claims outside of court, whereas if there were a time period running, they might feel it necessary to file a lawsuit before that process took place. And so the benefit to the district of something like this would be the increased likelihood that parties who oppose the measure wouldn't feel it necessary to proceed right away with a lawsuit and would instead take the time to negotiate. But it does not preclude a lawsuit, if that's your concern.
That is my concern.
If somebody does file a lawsuit, does it in any way impede our ability to defend ourselves?
It does not.
So if someone, because you have 39 purveyors, if one of them decides to file a lawsuit, we can still defend ourselves.
That's right.
And that would, and so the basis of this is really to limit the number of people that would participate in that lawsuit to hopefully zero, but it could be 2 or 3 or 4 outliers, which would make it easier for us to defend.
That's right.
Yeah.
The central purpose of something like this is to allow there to be more time to talk before anybody feels it necessary to file a lawsuit.
Mr. President, if I may, we have to understand that this district received, if I'm not mistaken, 32 letters of opposition. And there was a serious attempt in immediately filing lawsuits against the district. Now, I also am going off the memory, but you can help me out with that, Kevin, if you remember, or anybody else for that matter. I think it was at the July 10th meeting when the legal representative of the other side, when we decided that there is a potential and possibility of working a resolution out in the open. There was not a secret that they offered. They suggested to draft the resolution, framework of the resolution, so that it could be sent to the district and we could look at it, change it, edit it, restructure it if we wish to do that. But this is a very typical resolution of a tolling agreement. This is not very much different from any other ones that you have seen, Council.
That's right. Doing it as a resolution is a little bit different, but the effect is the same.
It is the same, right? So it didn't change that, and we had ample time and adequate time, based on your advice and the advice of your colleagues, that if the district wanted to make any changes, substantial changes to this document, we had the opportunity to do that. But it's simply that we didn't see the necessity to change the framework, the essential framework of this resolution, because it was agreeable to us. It was agreeable to our general manager, and it was agreeable to our council, with the exception of the certain edits that has been done, the redlining. Correct?
Correct. I mean, it's not, if we would have drafted it, it probably would have had less restrictions in it, less certain wording about Coskin, but it's an acceptable one that we can live with, and
Well,
that's the
it is a
nature of compromise.
compromise, right?
It's a compromise and we can live with
Avoid
it.
lawsuits.
Yeah.
And, the other thing that we have to remember is, constantly on this board, we have questioned the legal expenses. And if we wanted to have the legal counsel to draft a resolution or a framework of the resolution, there will be some charge attached to that, and then we would question why we're spending the money on the lawyers. And so rather than reinventing the wheel and doing that, we took the framework and the bones of a resolution that was given to us. We checked it. We made sure that district interests are preserved, that we are not giving up any rights. And that's the piece of document that is before us today, Mr. President.
So, moving along, in this discussion, there's also, I guess, a clause that says that we're going to create a fiscal sustainability committee. Is that the same committee that was created by the board several weeks ago?
Yes, ma'am. Yes, ma'am.
That's that same committee?
Yeah.
Has that committee met?
Not yet, ma'am, until we adopt this resolution.
Okay, because my understanding during the last board meeting, when the meter charge was passed, I voted against it, but when the meter charge was passed, that the committee was going to meet over the next 6 months to provide input around these issues. And so now there seems to be a mission statement around what this committee is going to do, really without any input from the elected directors that serve on this board.
Correct.
There seems to be a very interesting dynamic here on this board now that we have the appointed directors that serve on this board. I know that I've been here for the past 2 years, and I have had a great working relationship with the appointed purveyors. In fact, I have supported a number of cuts that have been proposed over the past 2 years by them. In fact, in my time on this board, we have made a number of cuts. When I first came on board, we cut our federal lobbyist, we cut our state lobbyist, we released an engineering firm who provided 4 engineers to our agency. We made a number of very immediate cuts. Over the past 7 years, this agency has continued to cut because it has recognized the need to be more fiscally in line with the revenue that was coming in. And so those efforts have certainly been made. And I have requested that our staff provide those numbers so that we can make that a little more public, hopefully in one of the upcoming committee meetings. I believe that it's very important for our elected directors, to have a voice in this process, and I don't believe that that's what's happening here. And
I agree.
So I hope that the elected directors, as we proceed with these conversations, that we are able to put our positions, in the record about the tolling agreement, about the mission of this committee, which has been created, which appears to be focused on making further cuts in this agency. I believe, we have an obligation to do that, and I hope that these conversations will continue.
Mr. President, if I may, nothing precludes this board as a whole to have an input in the process. I'll refer you back to Section 2, D2, which says district representatives, and in there, because we have been clearly trying to make a distinction between appointed and elected officials, but nonetheless, there are 2 elected directors, Hawkins and Camacho Rodriguez, and by nature of a ad hoc committee represents a board. So the board members should, and hopefully will, feel free to provide their input to their representatives. Now, if you want to talk to Director Hawkins and Camacho Rodriguez, you're more than welcome to do that. If you want to talk to all of us, you're more than welcome to do that. But the opinion of the board is going to be reflected in the negotiations through your representatives. And in order to balance the representation, you have 2 members from the elected and 2 members from the appointed. So I don't see any reason whatsoever for the ideas that other directors may have, concerns that they may have, not to be relayed to the other members so that it could be used in the process of negotiating with the purveyors. And by the way, fiscal sustainability is not just cuts. It's a combination of prudent decisions as far as future expenditures, and of course relying on additional sources of revenues in the future. So it has to be a balanced solution, which it will.
Director Apodaca, if I might, two things. One, at the prior meeting when we board appointed the committee, they also requested that the committee respond back regularly with a written report, I believe it was.
That's correct.
Of this, and so the board will be in control of the process, not just the committee. In others, the board will be fully, I think there was a big discussion about that at the last meeting.
It's an advisory committee.
Yeah, it's advisory. They can't take any action. The board has to take all the action. And that's item 5, the board retains ultimate authority. Also, I have a request to speak from Christine Carlson from Alshar and Winder.
Okay, before she speaks, I have a few things to say. Kevin, when we even discussed the situation about the meter charge, the first thing was $10, then we said $7, now we're at $2, right?
Correct.
Okay. I myself, elected director, along with Phil, along with Leticia, along with Martha, did we have any input on what's in there now?
Absolutely.
Okay. You tell me one thing that I inputted that's in here now.
Okay. What happened, Director, as you recall, the first budget that we presented you had a fixed charge based on a rate study of $4, and I believe it was 64 cents.
Correct.
He's referring to this resolution.
Yes, to the resolution.
Referring to the
I thought you
resolution.
were talking about the fixed.
No,
Because we haven't had any say in this resolution.
Well,
This
that's
is
what- and the-
before us now, and the agreement was that an ad hoc committee was going to be created, which it was, but it's never been activated to have these discussions so that this board and this decision is, as we move forward with this decision, that the elected director's position is properly represented, and that's absent from this
And then
resolution.
we also talked about an ad hoc committee. There has not been one meeting, and all of a sudden, this is before us again, somebody's yelling, the sky's falling, we need to make a decision today.
I think there's...
Hold on.
I didn't know you...
I feel that somebody is trying to push this down our throat. I mean, there's been no discussion with the ad hoc committee. The ad hoc committee was created for that reason. And this is here before us today for a special meeting?
Again,
And the other thing I said, no cuts. I don't believe in cutting one employee.
I understand that the board voted differently, and that's...
Not me.
I understand that, and I appreciate it, believe me.
And I do want to, I'm not sure if you're aware of this, Ms. Nichols. The other concern that arises as we move through this process is, obviously, we have been informed and placed on notice that we'll likely move forward with litigation if this tolling agreement is not approved, that we actually have individuals from the purveyor community that are their representatives, that the purveyors elected to this board, that voted for this meter charge. So there seems to be a very huge contradiction here in terms of actions, and I'm really interested in seeing how the judge is going to react to this. We have 3 purveyors that are elected here by the purveyor community. They voted for the meter charge. I voted against it. They voted for the meter charge, yet they're threatening to sue us for the same meter charge that they voted to institute.
And some
there's some
directors,
contradiction
some
there.
directors own shares in their water agencies. That should be illegal. Former directors own shares and were voting, to benefit their own agencies.
Mr. President, this is not the first time we're looking at this resolution. This resolution, the language has been out there. If you recall, we had a meeting, was it 2 weeks ago?
Yes, sir.
He was there then. Look, if any of the members intended to have an input, they had plenty of time to provide the input, like they do with other items. So the fact that this resolution is before us again today by no means equals to someone trying to shove it down our throats. Look at the prospects. Let's draw a line, clear line between what ifs. What if we don't pass this resolution today? Two things is going to happen. You're not going to have a rate increase. And as I've said it a month ago, and I'm going to repeat it again, you're going to invite all of these folks to come and sue the district. They've said so, and they will.
Mr. Skew, we're not having a rate
I'm
increase.
sorry. I'm going to have to finish my statement. I asked the chairman to allow me the time. So it is to avoid that. It is to avoid the lawsuit. Precisely in the best interest of the district that we even contemplated this resolution that is before us today. It avoids a lawsuit. It gives us some breathing room to work out through our problems. Now, if you didn't do that, again, you're inviting the district to be exposed seriously to legal charges and claims and lawsuits, which is going to cost this district the money that it doesn't have to spend otherwise.
Director Camacho Rodriguez.
So you just made the comment that we would not be able to have the rate increase. So did we pass a rate increase? Because I remember voting to pass the
Yes, we
rate
did.
Yes, we did.
Yes, we did.
And then making reference to page 1 of the same whereas document we're looking at. So June 24th, my understanding was the 10th is when we did the vote. So this is June 24th?
That was when it was proposed for adoption. It was voted, it wasn't approved. The budget was approved on the 10th, you're correct, but that's when it was proposed.
So I'm looking at a lot of the wording in this document, and I'm not an attorney, so that's why I appreciate Gina being present. Thank you, Gina. And so there's a lot of contradictions where we're giving up our rights. For example, on page 1, it would be the second to the last whereas at the bottom, where the sentence starts, meter charge would sunset and the purveyors would retain any right they have to challenge the legal validity of the meter charge. And so while I'm reading contradictions that we can vote to have a meter rate increase, that we can do our own budgets, but then we have wording that contradicts our right to do this without the input of the said people in this party. So I have issues with a lot of the wording. And so I would have appreciated, just for the sake of our constituents, because I think the ratepayers, Mr. Alshire mentioned that he was representing the constituents, as a lot of us on this board do as well, that we would have read out each whereas, so as people that are listening who are not here present today would understand, the same questions that they said, well, that sounds like a contradiction. So why would you vote for things that are not making sense?
Director, so the whereases are actually just background information, but we can read them out. I think in the interest of time, Director Skewy started with the action part of it, but we could read out the whereases. I think that's easy to do because we have edited those and I believe they're all correct, even though they're somewhat contradictory, as I say. But the other thing to remember, and again, this is not where we want to be in a situation with as a wholesaler with retail agencies, but we're suspending. We're not giving up any rights. We're suspending. But we're not the problem. We can sue any time, but we're not the ones that are going to sue. What we're doing is protecting ourselves from suits from a bunch of people. Now, if anybody files suit, as Gina said earlier, we have all full powers of the district to go and defend ourselves any way we want. And I think that's one thing we have to retain no matter what. All we're putting up is a framework for negotiations. That's all this is. And when you go into the negotiations, the wording isn't ideal. Many of it is slightly contradictory, but the intent is good. The intent is that we work together to solve the problem. That's what we're trying to remember. It has been, I don't remember when the first draft of this came out, but it had to be right after this 24th meeting or at the 24th meeting. So the draft in one form or another has been around for a month.
Yeah.
We've discussed it at...
Mr. Chair, if I may clarify something that Kevin said. This is a 3-year rate, essentially. right?
Yeah, for that
Although
rate,
we
yeah.
adopted it for 1 year as part of our annual budget.
Right.
It was just 1 year. It
That's
doesn't
right.
give us another 2 years,
No,
right? This resolution does, though.
yeah, this was, at least for the people who will honor it.
Right.
It gives us 3 years with the fixed charge
So
at
that's
$2.
the difference.
Yeah, that's not the action that was taken at the board meeting. I really encourage everyone to watch that video. I'm really glad that was one of the things that we first did when I came on this board is make sure that our staff was recording these meetings so that we have a crystal clear record of the things that are discussed, the recommendations that are made by our general manager, our general counsel, and the discussions that are made by our board members. With respect to, there are a couple of comments that have been made with respect to this tolling agreement, and one of them was that if we don't pass this tolling agreement, that we're inviting the district to be exposed. My understanding is that this tolling agreement is between the cities, and between all of the purveyors and the Central Basin. Is that accurate? That's what it reads.
That's where it gets a little complicated because it's being done as a resolution rather than an agreement.
Okay.
But that is the intent that's expressed in the resolution,
Right.
yes.
Which has been one of my concerns, is that there hasn't been an agreement by all the purveyors. So even if this resolution is passed today, it doesn't prevent any of the purveyors that aren't or haven't been represented here. I believe the one purveyor that has been speaking out on behalf of their city, that is very clear in the record, is the city of Signal Hill. Although he represents himself as representing other purveyors, we don't know who those purveyors are. There isn't a record of who those other purveyors are that he's speaking on behalf of. My point is that it doesn't, by approving this tolling agreement, it doesn't prevent the other purveyors from moving forward with litigation. So I just don't understand, again, how this could be beneficial for this agency. And again, the discussion was, and the agreement was that we were going to form an ad hoc committee. The ad hoc committee was going to meet over the next 6 months, and they were going to work through all of these issues, and I think that that's what we need to do. That's what was voted on. That was what we committed to doing, and I think that's what we should move forward with.
Yeah, I'd like to piggyback on that, because at the last meeting, we voted to install the $2 meter charge so that we could respond to our bond people and we would be able to finalize our budget. In that, right after that, we said that we were going to activate the ad hoc committee. We were going to add one member, which was Martha, to put on that ad hoc committee so that we could negotiate or review or talk about this particular resolution. 1 week later, we get a notice that we're going to be sued. What happened to this? We were going to have the 3 to 6 months for the ad hoc committee to review this, to work on it, to negotiate, and to do whatever we needed to do. All of a sudden, we're forced into a lawsuit or a possible lawsuit when we agreed at the board meeting that we would have 3 to 6 months to work on this. What happened to that?
Director Apodaca, I might mention, the misunderstanding we have is that the intent of this resolution is to provide the framework for this ad hoc committee to work so that our 4 people can meet with their 6 people. That's what this is. It's the framework for the negotiations.
But if we vote on it, what are we going to negotiate on? We've already...
You're negotiating on what is going to be done for the long-term solution of the district. This doesn't impair anything we do. It strictly means, it says we're going to provide 4 people, they're going to provide 6. Nobody's going to sue each other, hopefully, over the next 3 years if we do. And we'll have 6 months for this committee to come to a conclusion, give a report to the board, and the board will act. So you're going to work 6 months, you're going to give the board a recommendation. After that, the board will either implement the recommendation or not, but it doesn't constrain anything we do, it's just a framework to negotiate. These are the goals we have. We all want the district to be fiscally sustainable going forward. They believe there's another way other than the fixed
We
charge.
go into an ad
I may
hoc
not
committee,
agree.
the first thing they're going to say is, we've already voted on that.
Correct.
So we've already voted on it, what is there left to negotiate on at the ad hoc committee? Why have it?
The ad hoc committee is to discuss the financial structure of the district, fees, other fees for the parcel charge implementation. Is it an alternative to the fixed charge? Is there something we can do, refinancing bonds down the road to save money? It's to look at the financial structure and come up with a long-term fiscally sustainable plan for the
So then the ad
district.
hoc committee has nothing to do with this then?
That is the function of the whole ad hoc committee. It's yourself, the four
You can't have
directors.
it both ways. You're saying we're going to vote on it and it's a done deal because we voted on it. Now we're going to go back and negotiate, but we're going to do long-term finance and we're not coming back to this.
No, that doesn't make sense, Director, I'm
I
sorry.
know it doesn't make any sense, but that's what you said.
What you're stating doesn't make sense. That's not the intent of this.
Kevin, then this should be an information item only, and we don't take a vote today. Because
Well-
whatever's on here, we're gonna have to stand by this if we vote on it today and it passes.
That's the purpose of a resolution. You vote.
So it should just be a discussion item. So that way we're not held by this.
So are you proposing that you just go and start negotiating without any framework?
I'm proposing that there's an ad hoc committee meeting and there's discussion taken before both parties, and then whatever comes out, then we put it in here.
Mr. President, with all due respect, you have to have been present in all the proceedings in order to have a background for everything that has happened, to understand why we're doing this today the way we're doing it. And I know that regretfully you had not been able to attend all the meetings, Director. But Director Hawkins, I honestly think that there's a misunderstanding about what the ad hoc committee is supposed to do. What is it supposed to do? Here it is. As you know, all negotiations, successful negotiations are done based on good faith effort that is put in by both parties. Without it, negotiations fail. In order for both parties to have that understanding that the negotiations are going to be done in a good faith manner, we put forth this resolution that sets up the framework for that. Okay? The ad hoc committee, this is the adoption of this resolution is the start button for the ad hoc committee to start its work. Because without this, honestly, ask yourself this: what is the incentive or what trust do they have, the Purveyor community, that the district is going to follow up on its commitment to meet regularly with them and take them seriously in absence of having a resolution that sets the framework?
We got the same thing and we thought we had some kind of agreement. A week later, we're getting the threat of a lawsuit.
No, the agreement is spelled out in this resolution, sir, and it is true. It is not going to avoid 100% the possibility of a lawsuit. You may have someone on the left field coming in and filing a lawsuit. That's not going to change anything
Shouldn't agree to any
today
of
from
this.
tomorrow.
But see, we know that's going to happen.
Right. However, the
whole thing.
tolling agreements and the tolling language minimizes the exposure by the district. It doesn't avoid it 100%. Nothing avoids a lawsuit 100%. The tolling agreement, and again, folks, look at it. We're not the only ones who are doing a tolling agreement. Between agencies, and in the past, there have been tolling agreements in the past. This is not this is nothing new. This is not a new concept that we are so unsure about.
It is a new concept to us.
I
Totally
understand, and
new.
you're trying to
So you
explain
got to
it, and
treat
you're-
us as though we are brand new. And the other thing, going back to the ad hoc committee, I was at the first one that we had. Technically, I didn't participate. I listened to this agreement. You explained
I'm
this.
sorry, which ad hoc committee was that? Which meeting was that?
I don't know. We went to one. It was held here. You were there. Held in the room over there.
You had one meeting where there was just the three of you. Yeah, you
Yeah,
had one
but-
meeting, it was just three.
Yes.
Yeah, but the ad hoc committee, yes, but
And
Are you
basically
referring to
what
me?
they did is, this is when I seen this and it was explained to me. And I had a lot of questions and I says, I haven't checked with my finance guy, I haven't checked with my attorney, I haven't checked, but I did listen to all this. So then we come to the last week, or our last board meeting, and we say we're going to make sure the ad hoc committee meets again. We're going to add a member so that we can so that we can have ongoing negotiations. The next thing I know, and that's why I abstained on this, because I thought we needed more time to understand this, to have our attorney look at it, to have our finance guys, and have the board go through all this. I abstained because I said all along, and I said in that ad hoc committee, our board is not on the same page as everybody else. I had some information, you had some information, this had shown up, we need everybody on the same page. We need some time to go through all this. I thought the trade-off was we were not going to accept a $2 toll charge for 3 months, so that we had the 3 months with the ad hoc committee to negotiate all of this, and now it's all gone. I don't understand any of this that we've done. It's like we just contradict ourselves and we react to whatever happens that day. And I don't think that's the way this should be handled.
Quite frankly, Director, forgive me, Mr. President, I don't know how it could be confusing or how it could be last minute. We've had this in front of us for a month now. If honestly there was an intention to ever pass this resolution, if any member of this board had any questions or reservations about it, there was ample opportunity to bring it up and discuss it. I mean, this is not the first time we're looking at this, right?
See, that's not true.
2 weeks ago,
First of all, I said in that last meeting, we have the Brown Act. Who am I going to talk to? I get to talk to one and maybe two. I says, we need to have a board workshop. We need to have a board discussion on this so that everybody gets on the same page, and we've never had that.
I do want to make a comment also. I mean, there's just so much misinformation that is being put out. And I certainly respect everyone's experience and everyone's position, but I don't appreciate some of the spin that is happening with the words that are written in this resolution. And there was a comment that by approving this tolling agreement, we're going to minimize our exposure. And that's just totally false. What we're doing by approving this tolling agreement is actually extending the right for the purveyors to sue this agency, to pursue litigation against us. So I'm not sure that by approving this tolling agreement, which is not in the best interest of our ratepayers, is even beneficial to this agency.
Mr. Chairman, Mr. President, what is in the best interest of the district? To be sued and to spend money on lawyers? Is that in the best interest of this district? That's the question. And spinning and word, smithing and all of that. If there are any questions, here we are. This resolution is in front of us. If there is any ambiguity, please ask the question. If there are any questions or any changes that you would recommend to the language, let's consider that. We can consider it, edit it as we're sitting in here today, and make it a document that is going to be agreeable to everyone and move forward. But just we keep saying that we haven't had the opportunity to have an input. Again, we've been looking at this document for the last month. We looked at it at the last meeting, we didn't get anywhere. So if there were any questions or reservations that should have worked out between 2 weeks ago and today, there was ample opportunity to do that. It tells me that, honestly, we don't have the intention to pass this resolution.
This is actually a newer version of the resolution that was brought, before this board 2 weeks ago. So your statement that we've been looking at this for 2 weeks is just totally false. The other thing is we had discussed that an ad hoc committee would be created so that these issues could be worked out through the ad hoc committee. The ad hoc committee has not met. The only individuals that have met throughout this process are the representatives from the purveyor community. Those are the only individuals that have met. When Director Hawkins suggested that the elected directors get together and discuss a resolution to this issue, then he was accused of possibly violating the Brown Act, when all along the purveyors have been having meetings to bring their particular proposal to the table. So there hasn't been enough time, and I believe we should continue to work with this committee that was created for that purpose to do that, for the directors, the elected directors, to review the resolutions, not just the one on the tolling agreement, but the other one about the meter charge, and bring back recommendations to this board.
Director, I make one quick comment. If we don't pass this resolution, I think there's some confusion about the ad hoc committee. It's not an internal ad hoc committee, it's an ad hoc committee designed to meet with the purveyors.
Right.
Without this resolution, will the purveyors meet with our ad hoc committee? In which case, that's fine, and go ahead and meet, but just under risk of lawsuit. But I don't know if they will. This was kind of like a condition of good faith on our side so that they would meet with us and negotiate. But that's so, I mean,
If we vote on this, why have an ad hoc committee? That was my other question.
this doesn't solve anything. It does not solve a single problem financially of the district. All it does is provide a framework to negotiate with our retail agencies and come up with a financial plan.
But the
We have the
person,
alternative, we can just do it ourselves. We can go ahead and do it. That's perfectly, go and say, okay, we're not going to do this ad hoc committee, we're not going to negotiate, we just want to do it our way, and we can do that.
Sir, that's not what's being suggested. This board is interested in working with the purveyor community, just as it has in the past, but that has not happened. And the goal is for that to happen, for us to move forward, working with this committee that was created to hash through some of these issues. So I think we should continue to do that.
Mr. President.
We should put off action on this matter and until the committee has time to meet.
Mr. President, we are making a lot of assumptions on behalf of the purveyor community and how they prefer to continue this, if there is going to be any continuation of any negotiations or discussions. So we should invite the speaker to come up.
Yeah, Christine, go.
And perhaps address that. But my presumption is there will be no interest to meet and confer with the district if this resolution is not passed. So the ad hoc committee, let me clarify, the ad hoc committee is not just the 4 members on this board. That's one side of it. That's the side that is representing the board. The other side of the ad hoc committee would be the representatives from the purveyor community. So that let's call it a working group. That working group can start its work if this resolution passes. We keep referring to why don't we meet with them? Why don't we? Because they don't want to. Without the passage of this resolution, they don't want to meet.
John.
And that's okay. If
but they agreed to it. They agreed to 3 months, we would continue
First of all, it's not
negotiation for 3
3
months.
months. First of all, it's
Let's
not-
live up to the agreement.
it's not 3 months, it's 6 months.
Okay, 6 months.
And then
But we did 3 months, so we wouldn't collect the $2. We went 3 months, we wouldn't, so we could continue negotiating on that. It's gone to 6 months, and that's okay.
That's a separate.
But that's
totally a separate issue.
what this is all about.
I think Director Hawkins, some of these questions that you're raising, I think it could be answered by them. Do you want to hear from them?
Sure, I want to hear from everybody.
Okay, go ahead.
Hello, good morning. I'm Christine Carson from Elshire and Winder. Dave Elshire asked me to be here on behalf of Signal Hill. He's out of town today. On June 18th, 2019, City of Signal Hill submitted a protest letter and protested the proposed fixed charges on the grounds that the rate study and proposed fixed charges failed to meet the burden to demonstrate an exception to Prop 26 applies, and that any exception to Prop 26 requirement of a vote of the electorate applies. So we argue that the district failed to meet that burden. In addition, we have the problem of it's very unclear whether the district adopted the rates and charges, and if so, on what date. At the July 10th meeting, the board considered agenda item 6 regarding the rate study, the fiscal year budget, and the proposed resolution regarding the rates and the charges. After discussion, the motion that ultimately passed was to approve the budget with various reductions and to return on July 22nd with a subsequent resolution that became Resolution 07-19-980. Oh, sorry. To address additional issues relating to the charge. At the July 22nd meeting, the board considered agenda item 14, the proposed resolution 07-19-980, and it was not approved. The board also considered agenda item 14.2 regarding the water rate study and the proposed resolutions regarding the charges and the rates. The resolutions and water rate study were also not approved. Following the meeting, we attempted to clarify what exactly happened and what the position of the district is on whether they adopted the fixed charge, and if so, when, because obviously we have a concern that our statute of limitations may be running. The response that we got was unclear, that there seemed to be some disagreement within the district on what happened when. So the motion to approve the budget on July 10th did not on its face include the associated resolutions. And this is evidenced by the fact that proposed resolutions 07-19-984, the charges, and 07-19-985, the rates, were considered and voted on at the July 22nd meeting. So this would have been superfluous if they had in fact been adopted at the July 10th meeting. But nonetheless, it came back again for consideration. So we think this makes it unclear why the July 22nd resolutions existed at all if in fact they had been adopted on July 10th. There have been meetings. There was a meeting July 3rd of the Fiscal Ad Hoc Committee with purveyors. The resolution being considered today was presented. So the district has had it for several weeks. We understand there have not been edits to it since that time. In addition, the adoption of the budget was with the idea that it would come back and then that the district would then consider and presumably have the opportunity to approve the tolling resolution, but that didn't happen. And there has been some discussion by a director that the parties agreed to discuss, tolling, or agreed to discuss the charges. However, that's never been put in writing, hence the resolution that's being proposed today. So I understand Ms. Tunnicliffe from City of Signal Hill may have additional comments, but those are my comments in regard to agenda item 3, and I'll also have the same comments for agenda item 4.
Ma'am, Ms. Carson, I do have some questions before we transition over to your Public Works Director. Your attorney, Mr. Alshire, your firm has represented itself as representing some of the other purveyors. Would you let us know who those other purveyors are?
We are here on behalf of Signal Hill.
Okay.
I understand that there were approximately 25 purveyors that had an opportunity to look at the proposed resolution, and Ms. Tunnicliffe can answer to that, but I'm here on behalf of Signal Hill today.
Okay. Now, has anyone from the purveyor community retained your professional services to represent them?
Not in regard to what we're doing today.
Okay. So it's
Our
basic-
firm is general counsel for Cerritos and South Montebello Irrigation District. I'm not sure, there may be other, I'm not sure if there are other agencies that we're also general counsel for within Central Basin, but I know of those three.
But I can answer that question for her. So the purveyors are all meeting as a group, and so at this time, we are looking at which attorney would represent us in litigation if it had to go that direction. So they may at a future time be the representative for that.
Okay, but for now, the city of Signal Hill is the only city that has retained you to represent them on this particular matter?
Yes, as far as I know, that's, and like I said, Dave Alshire is out of town right now, so I could check with him, but as far as I know, it's Signal Hill.
So you're one of the attorneys on staff?
Yeah, I work for Alshire and Winder. Oh, and I should also mention, Cerritos actually does have General Counsel Mark Steris, who does not work in our office, but I understand Assistant General Counsel, Assistant City Attorney for Cerritos is in our office.
Okay.
So I just wanted to clarify that.
But you're representing
Signal
Hill, and they're the only ones that have retained you on this particular issue, to represent them on this issue?
Yes.
Okay, thank you.
Ms. Kelly Tunnicliffe.
Yes, so I just wanted to clarify a few things, just to set the record straight. We created this ad hoc committee that did meet on July 3rd at the 24th or 22nd meeting, whatever that was, that occurred. There was the idea that was brought up by Dave Alshire to create this sort of tolling arrangement to give the purveyors and the district time to negotiate. The idea was that we created it within a very short period of time. It was within 1 week's time that we drafted that resolution. It was brought back a week later. It was agreed upon by the purveyors that were represented. It was put before the ad hoc, which Director Hawkins was a member of. We presented it at that time. The edits that have been made between July 3rd and the last board meeting are the same as that see before you. So the resolution you have today is the same resolution that you had at the last meeting. So just to clarify, you'd made a point that you hadn't seen it. It's the same resolution. We did subsequently meet with purveyors, and we have 25 purveyors that have agreed with the context of the resolution. So when you say that it doesn't provide you with any benefit, it does provide you with the benefit that you have the majority of the purveyors agreeing, where you would have individual purveyors that could be reacting individually. You have a consensus of purveyors that are agreeing to try and work with the district. So I think it does provide a benefit. Director Hawkins, you were concerned that this doesn't provide any benefit. So our understanding as the purveyor group is that at the meeting where you adopted the budget that included the $2 rate, that action included that it was contingent upon adopting the resolution at the next board meeting. And so when that did not happen, the purveyor community was very upset because we felt that there was not a good faith negotiation. We felt that we were coming to the table to offer something because, remember, the purveyor community does not believe that the rate charge is a legal charge. So we still stand by the Prop 26. The clock for us has started on that July 10th meeting. And so by not adopting this, what this resolution does is it only allows us to work together. But by not adopting it, what you're doing is our clock has already started. And so we're not saying that there's anything in here that has to occur over the next 3 years. All we're saying is that we're agreeing to the conditions that you adopt as your budget, and that we're going to work with you over the next 6 months to adopt a long-term strategy. That's all this says. It doesn't say.
Okay, that
that's
wasn't
all.
my interpretation at all.
I understand. That's why I'm trying to clarify this for the
Yeah, not
record.
at all.
So there's nothing in this resolution that says you couldn't end up with a $10 meter charge. I don't know. I mean, if we work together over the next 6 months, and I think that is extremely unlikely, but there's nothing that limits where this negotiation goes over the next 6 months. That's my point.
That was my whole point when we started this, that we take the time, and I said several times, this board is not on the same page. We need some time to educate our board to bring this all, and then we never got that time.
Well, that's what this is. This resolution gives you that time.
We
Without this,
haven't had that time.
okay, this resolution gives you that time. By not adopting this, what this does is if the resolution is not in place, then the clock has started for the cities.
Your interpretation of the resolution and mine are totally different.
I understand. So I'd like.
Once we have a resolution, we have voted, we have committed, we are done. Once we do a resolution, unless we start all over again with something else. That's why we need the time to make this resolution solid. Not go in and say, okay, now it's time to start all over again, or we start the negotiation. Once we vote on this, we're done.
No, that's not true. If you read the resolution, all it does is it says that you are limited to a $2 cap over the period of the next 3 years. It says that we have accepted that you have a $2 rate in place, and that moving forward over the next 3 years, while we work out this long-term strategy for the financial security of the basin, that you can at no point put anything larger than $2 unless it's agreed upon. It could be agreed upon. We don't know what's going to happen. So all it does is it says our 60-day shot clock for litigation has not started by putting this resolution in place. If you don't put this resolution in place, then you've left the cities in a position and the purveyors in a position where they have no choice but to file litigation. That's all this resolution does. It buys time for both parties to work together to come up with a long-term solution. That's it. That's the only thing this does. And at any time...
I don't agree with that.
Okay, so maybe you can ask your legal counsel for an opinion on that.
That's what I said. We need time.
Yeah, I think the difference here is that we're representing two different constituents, and I respect, the position of the purveyors. I certainly respect that. I'm here representing, the best interest of the voters that live in my district, and I'm here to represent the best interest of this agency. And so I'm glad that we have been able to respectfully have this, conversation and this dialogue, and I'm happy that the conversations between the purveyor community and the elected officials that serve on this board have been very professional, very cordial. I think that's has changed dramatically from when I first got elected to this board 7 years ago. There has been over many years a lot of tension between the purveyor community and the Central Basin Water District, and in large part, the tension has to do with the fact that many of the purveyors don't want to buy water from Central Basin. Most of our purveyors have their own water wells. They want to be able to pump their own water and deliver their own water to their local communities. However, many of those purveyors are required by law to purchase imported water from Central Basin if their communities need that excess in water.
Director
And
Vasquez,
so
I think General Manager disagrees with you.
that natural tension, has been around for many years, and when I first came on board, I supported the addition of the board members of the purveyor community being represented on this board because I felt that your voice was needed here so that your position can be represented. Obviously, you have, now you have your representatives that are serving on this board that are advocating for your particular position. However, those of us that are elected by the constituents of this district also have an obligation to properly represent those people and make sure that we are an agency that provides the imported water that our communities need if they need it, and that's our role in this region.
Yeah.
And so we're doing that, and we want to continue to do that. Over the years, Central Basin expanded, its services. When Central Basin initially broke off from West Basin, It had a smaller staff. Over the years, we've adopted a number of programs and services, including our education programs that we implemented in our schools, our free bottled water program, our ability to have a staff member that monitors legislation, a number of additional staff positions that we have in this agency to help us carry out the mission of this organization that what I see the purveyors disagree with. The purveyors don't believe that we should provide educational programs in our schools. You know, those programs were eliminated. Some of the purveyors don't believe that we should provide free bottled water program. That was something that was brought before this board that hasn't been cut. Our purveyors believed that we should no longer have a water master. We got rid of our water master, which in my opinion was a bad decision that was made. The purveyor community felt that we should begin to give up our assets, including our asset in the city of Whittier, because they believed it was unnecessary. This board voted to give off our assets in the city of Whittier. The purveyor community didn't believe that we should have so many committee meetings. We combined our committee meetings so that the purveyors could so that we can move towards common ground. And it's been decision after decision that the purveyors bring before this board that a lot of the elected directors have, while we disagree with the position that's being brought, that the many of the elected directors have supported, including the elimination of our education programs. And I'm working on creating that list so that I can continue to share it in the public record. And so there has been a good faith, effort to work with the purveyor community. You have your representatives here. They are voting as the purveyor community advises them to vote. And so there's been a lot of good faith effort, is my point.
Okay, so a couple of things. I think that we represent the same constituents. I have my constituents in the city of Signal Hill are ratepayers. And the city of Signal Hill has an obligation to make sure that we are providing legal rates to those ratepayers. And so we are their voice. If we contend that the Prop 26 is in violation, it's our obligation to defend our constituents, which are also your constituents. So I believe that we have the same constituents, actually, and I don't think anyone is so anyway, I think we represent the same constituents, and I think that there's nobody that disagrees that Central Basin provides the service. What we may disagree on are what those services should be. And that's the discussions we want to have with you over the next 6 months. We're not saying that we don't value Central Basin or the services that Central Basin provides. I don't think anybody disagrees with that. We just disagree with the level of service. We need to make sure that it's a financially responsible position that the board takes. And that's our position.
Yeah, and I will say that this board has made substantial cuts in services over the past 7 years since I have been here, and I want to just share an example. During my time on the city council in the city of Linwood, I was able to get my first experience dealing with a municipal water company that provides services for the city. And one of the things that I learned, and I know that this is the case in a number of communities across the Central Basin Service Area, is that, it's not very appealing for city council members to vote on water rate increases. The city of Linwood had a system where they repaired their pipes when they burst. And so the city, for many years, I don't want to say ignored, but didn't address the infrastructure needs that it had. The city of Linwood at that time had been around for about 75 years, 77 years, and it basically provided a Band-Aid solution to the water infrastructure needs of the city. During my time on the city council, we brought forth an aggressive capital improvement program that would repair pipes before they burst. And that required for our city council to make some tough decisions. And one of those decisions was, to increase the water rates. And as a responsible elected official, I voted to increase the water rates. It wasn't popular, but it was something that was necessary in order for our community to continue to receive clean water over the years. So we've had to do that.
Yes.
Liberty Utilities is another example. They have water rate increases every, Mr. Hellman, how many years? Mr. Hellman, how often do you consider rate increases?
We have GRCs every 3 years.
Every 3 years. So every 3 years, our purveyors from the private water community propose water rate increases so that they can meet the demands of their organization. And most recently, they proposed water rate increases so that they can meet their increased financial demands, including funding for staff, funding for infrastructure improvement, funding so they can continue providing the services, the additional services they provide to their communities. So my point is that it's a very common practice for responsible water agencies to visit these increases every so often, and that's what we're here.
And we're not arguing that, but we're arguing the method for which you've put an increase. And the other thing I would like to say is you're making our point. So the purveyor community actually has no mechanism for passing on this increase to their constituents other than bringing back something before the board, which you yourself just admitted was very unpopular. So if a city has...
Yeah, Director Apodaca, we're getting off topic and we're not supposed to be back and forth. We have another speaker, Mr. Lara, who's been waiting to speak. And then we have other directors who wanted to participate.
Hi, good afternoon, directors. Andrew Lara, Pico Water District. I come as a friendly voice. I want to come from my perspective, but I want to make one thing very clear to you. You do not provide water to our constituents. I represent 5,400 connections within the city of Pico Rivera. As a board, we provide drinking water to our constituents. You do not issue water quality reports. We issue water quality reports. You do not walk our neighborhoods. You do not hear the complaints. We hear the complaints. So all the rhetoric that Central Basin provides water, drinking water, is non-existent. As Pico Water, we do buy some recycled water from you. In fact, about $20,000 a year. And at one point, when we went for our loan for infrastructure, it was a liability to be associated with Central Basin. They weren't going to give us our loan because we relied on money from you because they thought you were going to go bankrupt. The point that I want to make about this resolution, and I'll make it from my personal point of view. If you do not agree to this, you have 30 purveyors that are going to sue you, okay? Now, it's estimated that a lawsuit against Central Basin will be well over $100,000. Well, by 30 purveyors, you do the math. That's within our goal. We'd easily get $5,000 to sue Central Basin. If you do not agree to this, okay? If you do agree to this, then you take out a large majority of the purveyors. They will agree not to sue you. And if you have an outlier, like maybe 1 or 2 water districts, then they would have to burden that $100,000 of suing you. And say, hypothetically, if that water purveyor was Pico Water, say if we wanted to sue you, well then as each board member, we'd have to decide whether or not it's worth spending $100,000. And I don't think it is. I don't think as a sole fighter, we would take that lawsuit. So that's where we come from, because the legal opinions that we are hearing, and I want to piggyback for what the previous speaker said, we are being told that this rate charge is illegal. So, as a gatekeeper, as an elected official, as someone who provides drinking water to my community, I cannot allow an illegal charge to go through. If I allowed an illegal charge to go through, I'm not doing my job.
Mr. Lund, can
So,
I have a comment?
I'm sorry, with all due respect, I'm not finished. So, I look at this, and even for me, even agreeing to it is a hard pill to swallow, because it means we cannot sue you. But I think as a director, my personal opinion, it's a pill I'm willing to take, because it's a step in the right direction. And I get it, directors, there's things that need to be worked out. Maybe you needed more time for this. But this is goodwill. That's what you're agreeing to, with potential rate increases in the future. But if you don't do this, you have 30 purveyors that are going to sue you. And maybe this is a new dynamic for you, that the purveyors have formed a coalition and they're able to pool their resources, and it's easier for them. And maybe this is a new dynamic for you, that you have purveyors who are sitting on the board, elected people from the purveyor community, and now you're hearing arguments on the dais against each other. I've been coming for years, and I've seen the evolution of this district. And yeah, it is a new day. I'm sorry, Director Martha Camacho Rodriguez. I didn't mean to cut you off, but I just wanted to finish my point.
That's fine. So my understanding from our legal counsel, the day that we took the vote, July 10th, for our budget and the $2, is that that was not an illegal action. So
Yes.
my understanding, as we go back and forth with contradictions, is anyone can sue us absent of this paper. So this paper doesn't save us from lawsuits. There's nothing here that says we won't sue you. What I do see on paper from the purveyor side that was very crafty, thanks to Mr. Alshire, is that you put in a lot of restrictions before we even got to sit at the table to agree to draft a resolution. So you're asking us, as a group representing all of our constituents, that if we don't do this, you're going to sue us. You can still sue us whether or not you threaten us.
Yes, outliers can still sue you, and that's why I said it would be more difficult for outliers to sue, because now as Pico Water, if individually we wanted to sue you, we're looking at taking on $100,000, and I don't think that's worth it. I don't think that's worth passing on $100,000 to my constituents. And I don't know if we're going to win. And in regards to you passing your meter study, there are questions about that Raftalis water rate study. We don't think that it provides enough standing for you to raise meter charges. So there, of course, there's a difference of opinion, and those differences of opinion, of course, lead to lawsuits. This is trying to prevent that, at least from the majority of your purveyors. It's the majority that you're trying to stem off.
So that report, Raftalis report, and we'd like to thank them for crafting that, as it was similar to the Lakewood report on how they were able to increase their rate as well. So we can go back and forth, and we would never end.
Yeah.
But I think the beauty of coming together is that, we can go ahead and meet, and we each add to the table. But while this resolution does not have anything from our board representing our constituents, which is the same constituents that we all share, okay? My concern is, this is draft number 3 that I have seen, and there has been a lot of change to each one that came in the last couple of weeks. And the concern is that if we're going to say out of one side of our mouths that we're working together, but that's not the case that I'm feeling or seeing or reading, then that's a concern. We're still going to have to work together whether or not we have this on paper. That's a fact. But to be threatening each other you're threatening our constituents when you come here and you put out that we will sue you, we won't work with you if you don't follow this resolution or if you don't pass this resolution. My concern right now, based on a lot of what's going on, is that if I took the day today to come and give a vote, do a vote, that it's not a vote that was pre-planned. And that's how this feels, because you guys even made the statement that when we didn't pass the resolution, that there was an issue. And Al Shire put that in an email. Okay, so nobody's pre-planning a vote. When we come to the table, we have pieces of information, and as a group, we decide what is in the best interest as an outcome of our vote. So to even put it that we didn't pass this along with our budget and with our rate, that's pre-planned. And I don't want my constituents who are listening and watching right now to be thinking that we're doing deals, backdoor deals. Doesn't that sound a little bit like Bell?
You know, I think with all due respect, Director Martha Camacho Rodriguez, I think you're gonna have to make a judgment. You're the one who's taken an oath to not come to these meetings with pre-planned ideas, not to break the Brown Act. The purveyors have it. So, with all due respect, you're gonna have to make the best decision that you can, and that's it. I'm not gonna kind of go back.
We have some directors that are going to have to leave, so.
Yeah.
Director, I want to make one comment, please. I'm going to ask a question from General Manager. General Manager Hunt, are there differences between the resolution that we have before us today than the one that we looked at 2 weeks ago?
Not that I know of, and the only changes at that time from the original ones are ones that we made to improve it for our standpoint.
So
They haven't changed their position.
So this document before us today, this resolution, is
the
not
same as
different
2
than the
weeks
one
ago.
that we looked at 2 weeks ago.
Yeah,
Correct?
it's the same.
Okay, thank you.
Yeah, I think the challenge here is that the group, the committee that was formed specifically to review this issue hasn't met. And the only folks that have met to further develop their position are the purveyors and the purveyors on this board. And until we can come together and be properly represented, in my opinion, we can't move forward.
Mr. Director, again, I'll go back. The ad hoc committee has two components to it, okay? There is a component that represents this board, there are 4 members on there, equally from each fraction, lack of a better term. And there are then, the other side of it is the representatives from the purveyor group. That meeting, that initial kickoff meeting cannot happen unless and until we pass this resolution. That's the start button. That's the one that is going to say, let's start the clock on a 6 months effort. That's what it is. So I keep hearing we haven't met, we should meet first. What are we going to meet if we don't declare our intention to agree with a framework of cooperation? Why do we have to meet even? They're not going to meet with us if we don't accept the framework that is before us, the framework of cooperation. I mean, I'm confused. I keep hearing that we are not meeting and we're not meeting. What is the purpose of meeting if we don't agree to the framework?
Mr. President?
I think the challenge...
Mr. President, quick comment. For council and the general manager, let's just say, for instance, we were able to overcome our differences and pass this resolution today. Is there anything that precludes us to replacing it with a modified resolution at a later date once we've had an opportunity to meet?
It requires that we give 30 days notice.
Correct.
Any intent to modify or cancel the agreement.
So for instance,
that's the only constraint I'm seeing.
So for instance, if we were to pass this resolution today and begin good faith negotiations with the purveyor group and come to some agreement through that ad hoc committee that perhaps there needs to be language added or deleted or modified, we could bring it back to the full board for consideration. and make the proper adjustments at
Yeah,
that
we
point.
normally would notify one board meeting and then take it for
Correct.
vote the subsequent one a month later.
So the misconception of the fact that this is set in stone and there's absolutely nothing to do after this point because we're going to have our hands tied is not accurate. And I think that this is an opportunity for this board to reach out and work with the purveyor group and understand that we do need to work together. And I think it's a good starting point. And it's an opportunity for them to realize that, yes, we went from $8 million to $4 million in revenues. We also went from 28 million to $8 million in reserves. So we don't have the best record of running a legitimate business with our constituents in mind. And this is an opportunity for them to offer opinion to an ad hoc committee. That ad hoc committee then come to the full board with recommendations that represent the best interest of everyone involved. I don't think that there's a reason to believe that there's any transfer of power or any hidden agenda other than the fact that the purveyor group is stepping up, willing to give $634,000 a year to get through this hard time for the district. And I think it's ill-advised for the district to say that that's not enough, we want more, and if you don't like it, sue us. I don't think that's the proper message we should be sending to the purveyor group. Thank you.
I believe that the message that's being sent to the purveyor group is actually cooperation. And this board has created the committee. We have agreed to meet as a committee and to sort through these issues, and this has not been done.
Director, one last time. I'm sorry, Mr. Chairman. One last time. Director Hawkins, you mentioned that you had some issues with the resolution, right?
Yes.
But what are those issues that you have? So maybe you can sort it out.
Okay, the toll agreement.
Okay.
We are going to be sued whether we sign this or not. That's my opinion, that we are going to be sued. But we don't have any guarantees that we won't, so we're going to agree to all their demands with no reservation. What if we put in the tolling agreement that if they sue, then they take care of the lawsuit? We don't, because we're not suing.
I'm sorry, say that again?
Okay, what if they've got 25 people that won't sue? That means they've got probably another, 18, 19 that will sue.
But we don't have that in writing from them.
Exactly. So we don't have anything that they don't. So we're agreeing that what if we had something in this that said, okay, they will protect us from their other members. We don't have it. We've never even discussed it. I don't even know if it's possible. That's what I said. We need more time so that we can work through some of this stuff, or at least ask the questions. And we have not had that. And that's why I think as we go through each one of these with the ad hoc committee and with our members, we will have questions on each one. They will get answered. We will ask for options. They will get answered. And then we
Who's
can...
that? Who are you talking about?
Our group. Our
The four of
ad
us?
hoc group or the whole board, I don't care, as long as this side gets the information and gets to know some of this stuff. But we haven't discussed that. And I thought at the last board meeting, we were going to have that 3 to 6 months, 3 months of the ad hoc and another, then the 6 months to activate anything. And we don't have that
Director
now. We
Hawkins,
have 1
with all due
week.
respect, the intent of the ad hoc is not to discuss the resolution amongst us, right? That's the framework that is set in the resolution. If any of us, any of our members in here have a question or there are ambiguities about the resolution, before we come into the meeting and discuss it, before we vote, we need to explore and ask for answers to those questions that we may have. So when we come here, we are informed enough to be able to make a vote. So we're not gonna go back and forth on the resolution has been in existence for over a month. It's not very complicated. I think the only issue that I've been hearing today, that the one that you've been hitting on, is the tolling agreement.
Well, that's just one of them, yeah.
Well, I'm interested to hear the rest of them.
I haven't written down all my notes are not on any of this because I didn't think we were voting on it today. I thought we were going to discuss it all over again. But it's just some of this,
So adoption of the resolution is not enough when we see on the agenda that in the agenda there is a resolution that is recommended to be adopted by the board. That's not enough to say to us that.
no, because I want to go back to the last meeting where we had 3 months. And I'm still under that impression. That's why I didn't vote on it the last time.
Director, the 3 months, and my apologies for the confusion. Last time when we approved the budget, I put language in there, I said, and that we would suspend implementation of the $2 fee till October 1.
So that we have the 3
That was the
months.
3 months. That was the 3 months that we were going to do. But that simply had to...
That's independent of.
That's independent of this. Let me make a suggestion that might help with this. I understand the concern that we're going to file this, and it is kind of one-sided because we're basically still possibly going to get sued. At the same time, we want to start negotiating as soon as possible. What if we do this? Suppose we
Kevin, you got us in this situation the last time. You're acting like a ninth director here.
I'm proposing a solution to...
I know, but you created this problem the last time.
The last time?
Yes.
I created the problem by trying to solve a problem. We're not going to get into it here.
Okay, well, that's in your mind.
So there's so much discussion around the issue of litigation, and our attorneys, including Mr. Pellman, have indicated that we are following the law, that there is no violation of Prop 26. And so I don't understand why we continue to even entertain this whole, we're going to sue you, we're going to sue you. If we're following the law, and you've given us, Kevin, this recommendation came from you about this meter charge.
Yes.
And you've indicated that it meets the requirements
Yes.
of a Prop 26 challenge.
And we had a separate independent law firm verify it with some...
Right.
But let
So
me-
I don't understand why, if this is a legal charge, why we would even enter into a tolling
Because
agreement.
People have differences of opinion. We just won a lawsuit the other day we'll talk about later, but difference of opinion, that's what leads to lawsuits. One of the suggestions I was going to make is if we can see it on ourselves to approve this today, that we go out though, and I will go with the appropriate director to every city, every water district, every mutual, and every one of the 39 purveyors and try and get them to sign a tolling agreement with us. So that we have
Sir,
a
you should have
mutual-
gone to all of these cities and had conversations with these purveyors when you first introduced this meter charge, and you failed to do that.
Yes, beat me up all you like, man, but my proposal right now is that we do this over the next 2 months it will take. We should be able to go, and at that time, we'll know how many are going to support the tolling. In the meantime, we can be working on solving the problem. Otherwise, some of them will see it, maybe they have different legal advice than we do. Some of them will see it and will file a lawsuit. This way, at least we're in the process of doing two things: negotiating the problem out, because time is of the essence, and also trying to get as many people to sign the tolling agreement.
Kevin, I believe you told us in the past you went out and met with these folks, and they were all in favor.
That's
No,
true.
Hold
Never
on.
said that.
Hold on. All of a sudden, you said they were all in favor, you spoke to these people, this didn't start overnight. When we
never
had
said that to you, Director.
Kevin, when we had the discussion, it was over 6 months ago.
It's a public meeting here with the,
Hold on. I'm not saying here, we had meetings in your
get a lot of
office.
things made up of it.
Hold on. We had meetings in your office where you said, hey, everything's good, people are on board, Phil. Right? Remember that?
No.
Anyways, Kevin, I think your nose is growing, but
So
anyways, I
I'll
know
go
what I
ahead and make a
heard.
motion to defer action on this item
And I second that motion.
have the committee work through these issues.
Roll call.
Director Chacon?
Yes.
Director Haldeman?
No?
Director Origi?
No.
Director Hawkins?
Yes.
Director Scui?
No.
Director Vasquez?
Yes?
Director Camacho Rodriguez?
Yes.
President Apalaga?
No.
Motion does not pass.
Mr. President, we can bring up and relitigate all the grievances and the issues that some members of this board have with the general manager. That is not discussing the topic of discussion today. That is not helping the conversation at all. It's not furthering the cause of what we are considering here today. What we need to focus on is, as far as the tolling agreement, and the differences of opinion regarding 26, I can tell you this from personal experience. Our agency and a number of other agencies were involved in a lengthy 5-6-year lawsuit against another agency for the same exact reasons. We were getting a different opinion from our lawyers than the other agencies' lawyers were providing that opinion to them. It ended up in the courts. 6 years, and I think $4 million cost to the cities on 3 cities to one side, and I don't know how much the other side spent. That's what happens when people have differences of opinion. They litigate, and it ends in the courts. And somehow, sometimes they settle, sometimes they don't. We are here to avoid all of that trouble. We are here to do what's right we talk about our constituents. Would a lawsuit by any one of these entities be in the best interest of the constituents? At the end of the day, they are going to pay for the lawsuits. We are going to pay for it. It's going to be actually, it's a double whammy for them, because we are representing them. They're going to foot the bill, and on the other side, whoever is suing us, their ratepayers indirectly or directly are going to foot the bill. So who's benefiting from that? What do you mean, Council? For even posing that question. But it is to avoid all of those issues. It is basically to say, time out. We know there are differences of opinions, but both sides have expressed a willingness to resolve those differences of the opinion. Not sue each other. Avoid that trouble. Avoid that prohibitive cost. In the meantime, try to figure out a solution in the best interest of the district for the long run. What is so awful about that? That's the part that I don't get. And we keep punting this thing. We keep kicking this can down the road. Nothing has changed from a month ago on this resolution. Nothing changed 2 weeks ago. I kept hearing that the language has changed. The language didn't change. If we really are interested in working out a piece of document, why don't we ask the questions before we come to the meeting and draft something different, send it to the other side, say, do you agree with my recommended changes? And if they agree, then if both parts agree, then you adopt the resolution.
Sir, the reason why that hasn't happened is because when it was suggested by one of the elected directors that we do that, we were accused of violating the Brown Act. Even though, or potentially violating the Brown Act if we came together and had those discussions, all the while the purveyor community was meeting to come up with their proposal, which is on the table, and which, again, is another contradiction. So what the elected directors are asking is that we have an opportunity to work through these issues by way of the committee that was created.
Hopefully later on I'll take a look at the minutes of the meeting, that when we adopted the budget, when these folks were here and the representative, Mr. Alshire, was here, you stepped out of Director Hawkins, you spoke with Dave Alshire. And after that conversation, at that microphone, he said that the purveyors he is going to draft a resolution for consideration. We all heard that. We didn't say anything. We didn't say, no, I don't want you to do that. We will do our own. We will send it to you. We all agreed on that principle, that they are going to jam. And I remember it was a Monday, and he had to leave town at the end of the week, but he promised that he's going to deliver it by a Friday type deadline. We all agreed to that. We all said, okay, you do the hard work. You present a framework to us, and then we'll take a look at it. And if there are any changes that we're going to make and recommend, then we'll make those changes, send it back to you. That's a month and a half ago. That's 2 months ago. We haven't done that.
And that's what the committee was created for, so that we can do that without being accused of violating the Brown Act. And we are simply requesting that we be able to do that. And when the board agreed to entertain the idea of a resolution that included a tolling agreement, that's, the intention was to, and the agreement was that he brought forth a resolution for us to consider, not a resolution that we were just going to rubber stamp and vote yes on. And so again, we're simply interested in having the working group that was created, the committee, solely consisting of the directors that are elected on this board to have a conversation about this issue further. Otherwise, we're going to have a committee that's consistent of 2 elected directors, two appointed directors from the purveyor community, and 25 representatives from the purveyor community that are going to basically take control of the discussions in those committees and not even allow the elected director's position to be president to be discussed. It's very clear that the purveyor community, and I guess I should say the individuals that represent themselves as as part of the purveyor community that attend our meetings already have a position, and which actually doesn't totally reflect the position of the elected officials in those communities, because I've had conversations with some of them. So I'm interested in moving forward with, again, having the committee that's composed of the directors that serve on this board meet to continue to negotiate these issues.
We're negotiating amongst ourselves? We're negotiating with ourselves?
Well, it's very clear, sir, that the positions are different. And while you bring forward, this resolution that you agree with and you support, it's not what we all agree with. And I think that's where we are here, is we are not able to move forward with action on this item because of the disagreements. So if this committee, that's going to be equally represented by 2 elected board members and 2 appointed board members, can meet to iron through these differences and work out these differences, and maybe we can find a solution to this.
Mr. Director, we keep hearing about differences. First of all, how should I say it? I disagree with the characterization that you brought this resolution. I didn't bring this resolution. It's a resolution that has been worked out. Staff has put it in as they are, that's their duty to do. They make a recommendation, they make a package, and then we'll discuss it and move on from there. So I didn't do that. But here again, I don't know how many times there has been an effort to try to divide and clearly draw a line and a distinction between the electeds and the appointed directors. I'm not going to go there. Here's my suggestion, because this is the trend. The trend is just, again, kicking the can down the road. If we want anything to be done, I'm going to have a substitute motion in a second. But the 2 directors, I don't know if Director Hellman has some questions and some things that in the resolution that he wants to oppose and get answers. I don't. I've read it. I studied it. It's the same thing as I looked at two weeks ago. I suggest, in the interest of doing things more efficiently, those directors, Director Hawkins and Director Camacho Rodriguez, we are both on that subcommittee, submit your questions in writing to the general manager. That way, we can study it ahead of a meeting that we are going to have, and we would be able to address those things and walk into a meeting and have a productive meeting, rather than spending time back and forth without, hearing things like, well, I didn't write it down. I don't have my notes in front of me. Write your notes down. Clarify your position on any specific issue that you have. Like people who make comments on a legal document, and send it to the general manager. General manager will share it with the council, and then before we form this meeting of the 4 of us, we have all the information that is needed to have prior to a meeting, so that the meeting is going to be productive and the decision could be made.
I think you've missed the whole point. First of all, this board needs to discuss it as a board. We're talking about a committee, we're talking about a person, we're talking about somebody's notes, we're talking about something that still doesn't bring the board on. We have an opportunity here of having a 100% vote on this resolution if we get a little bit of time to go through and vet each one of these things and to find out what each member has that's for it or against it and move on through. We have not been able to do that. This is what I have said, even in that ad hoc committee. We need the time to go through all this and bring the board all on the same page.
Director, who's we?
We, everybody sitting behind this
what's the
dais
purpose
here.
of an ad hoc committee?
Everybody behind this dais has not sit down and gone through each
Why
one of
not?
these. Because we have the Brown Act, and unless we call
What is
them...
the purpose of an ad hoc
For
committee?
this meeting, wasn't it the purpose?
Bring the information back to this board, and that we have not been able to do it because the committee hasn't even met yet.
What is the purpose, how is the committee going to function? What is the purpose of forming an ad hoc committee, may I ask?
To form the information to bring back to the board.
Okay.
We have to have that meeting. We haven't had it.
Have you gotten your input from any other director?
Yes. That they're not happy. We need to go through this.
So they're just not happy, but they didn't say why they were not happy with particular...
No, because we have never even in the ad hoc committees, we don't have an attorney sitting there representing us to say this is good, this is bad, what the options might be. So how can the board have those options if they've never had it at the ad hoc committee, if they've never had it at any of the meetings? We need to have that, and we've never had it. That's why I said we
Yeah,
need
and
some time.
I will say that I have already put in the record on numerous occasions my, why I don't support this resolution, and I've done it over and over and over again. I think the problem here, sir, is that, and your frustration stems from your inability to get every director on this board to vote for your resolution. And that is just not going to happen because
It is not
each and
my
every one...
resolution. You keep saying your
The resolution-
your resolution.
Sir, let me finish.
No,
Please do not interrupt me.
You are directing it to
Please,
me,
sir,
and I
let me
have to
finish
respond
just
to it,
right.
okay?
Just like
It's not
you
my
have
resolution.
waited.
Stop that, please.
Excuse me. It is the resolution that the purveyor community has brought before this board and is not a reflection of the opinion and position of all of the directors that serve on this board. And that is the challenge. And so we're trying to work through this through committee, which doesn't mean, see, the whole purpose of us having an elected board is for us to have a debate and discussion about these issues. We have one board member that hasn't said a word about this. The purpose of having these public board meetings is for us to have a debate and discussion and to make a decision based on the information that we're getting here, not to meet in some committee to formulate a resolution or to formulate our decision about what's happening here. This is the forum for us to do that.
This was the forum 2 weeks ago, this was the forum a month ago, nothing is being done.
Director, let's...
It's democracy,
Director Vasquez
sir.
makes a point here.
Yeah, it is democracy.
Is there any other motion?
Excuse me,
Yeah, there is a
just-
substitute motion.
Okay, make it.
After I hear...
I just wanted to make sure, I heard Director Hawkins say he needed more time, but he wanted to go through this. I wasn't sure whether he wanted to do it in a committee or with the entire board. We started here with Director Skewy going through line by line, basically, through this.
I thought he was making a sales pitch.
He was reading it verbatim. The question is, would you like to repeat that process in 2 weeks?
I
You have
didn't
time
bring
to
you
read
in,
it?
did I?
Exactly.
But then if you had attended...
Are you the vice president? Are you the vice
president?
president, John?
Okay, Director.
You're supposed to reach out to everybody, not just to the appointeds.
Directors, my question is to Director Hawkins. How would you like to make sure you get your input? Do you want to do it through the committee or through the entire board?
I think the entire board should know about it, and I think the attorney should be there, and we would be able to ask questions.
So
Let me
can we
go
do
back.
it today?
Let me go back a little bit farther so that you'll understand where I'm coming from. We asked, nobody on this board, from what I heard, ever heard of a tolling agreement. Nobody had ever heard of it. What is it? We asked for an opinion. We got it this morning. Now, we should sit down and be able to ask some questions. What if we do this with a tolling agreement? What if we don't do this with a tolling agreement? What do we have to work with here? We don't know. We got this morning. That's what I said, we need time. We are going to make a decision on something, our constituents are going to say, why did you vote for, and pick out each item. We better know why each item and why we voted for it.
So would you propose to redo this and have a workshop in 2 weeks and walk through it line by line?
I think we should. I thought we had agreed to do that, and now
That's what I thought today was, yes.
Well, no, I didn't think that was it at all.
That's what we said, but we say it this time, and we really mean it. And the question is, we come back in 2 weeks again, and we will go through this line by line. We'll all have time to review it and make our comments. We'll have the attorneys here. Any questions you have ahead of time, you'll send to us. We'll get written opinions when we can, and at that time, we should be in 2 weeks, we should be able to make a decision.
I think a lot of this goes down to this tolling agreement that we don't understand it and we don't know what we're getting into. It looks like we're giving up a lot of rights.
It's just not in the interest of this agency, and is one of the reasons why I will continue to question our attorneys. Why is it that you're refusing to give us an opinion on this? That, for me, is another red flag.
Mr. President, real quick, if I might.
In writing.
Director
In
Hawkins,
writing.
when you say "we" exclude other people, I know what a tolling agreement is. I don't need to understand what it is.
In our board meeting, we asked and nobody said anything. They said they hadn't heard of it either.
Director Hawkins, are you going on record as saying that as an elected official of a local agency, there is no knowledge of what a tolling agreement is, even after a month that we've been talking about it?
Sir, this is not a forum for you to ridicule and to try to shame and embarrass other elected officials, okay? We're requesting a legal opinion here.
You gotta leave, it's 12:09.
We're requesting a legal opinion here that we have not, that our lawyers have refused to give us. And I don't see why our attorneys are refusing to give us this legal opinion. We're making some very important decisions on behalf of our constituents, and they're refusing to provide us with the proper information. So if you're interested, I haven't received, we have not received it in writing.
Which legal opinion are you talking about?
The legal opinion about this tolling agreement.
Oh, I gave you that months ago.
No, you didn't.
Kevin, if I may,
No, you didn't.
I'm sorry.
the president recessed the meeting, is that what we heard?
Yeah, you pass it on to me. We're going to take a 10-minute recess.
So where are the answers, Judy?
Mr. President, I think this board has enough information to move forward with this resolution. There are some questions with regards to the tolling agreement. I think our attorney provided the definition that I read off to you this morning. Let me just reiterate. All we are trying to do in here is to create an opportunity for the two sides that disagree on a particular issue to have, lack of a better term, some breathing room so they can work together to resolve those differences. In absence of this condition and this framework, there is, let me be very clear, as they have been very clear, there is a serious and imminent danger of the district being exposed to lawsuits. And we as members of this board, we have to minimize, not just with this particular instance, but with any other instance, we have to minimize of exposure, legal exposure for this district. This just does that. We keep talking about the ad hoc committee, ad hoc committee. The ad hoc committee, the committee consists of two sides. Representative of the directors who are supposed to gather information from the other directors to see what their concerns are and discuss that. And there's the other half, which are the purveyors. They are supposed to be doing the same thing. Their representatives reach out to the other 32, gather the information, gather the points of views, and discuss it with the representatives of the district so that in a good faith effort, we can resolve our differences and move on. And we have ample time, 6 months ahead of us. And by the way, nothing says that if progress is being made, the 6 months cannot be 7 months or 6.5 months. As long as we are achieving results and we are resolving our differences in a positive manner, it doesn't really matter if it's 6 months or 7 months or 8 months. Remember, the bottom line is for us to be able to find a resolution to the long-lasting, regretful financial woes of this district. Structural deficits, financial deficits. We're trying to resolve that. This gives us a platform and an opportunity just to do that. We're not giving up any rights. If anyone sues us, we can defend ourselves. Absolutely, and this document says that. With the parties that we are agreeing with, we are saying, time out, we've got 3 years, let's work it out and move on. You're also right, Director Harkins. They, each one, in order to solidify this concept, each one of them have now to go back to their governing boards, whoever that might be, a city council, and ask them to ratify a tolling agreement. That was the whole idea, that after this, each one of their cities or entities are going to ratify a tolling agreement with the district so that individually we will have the assurance that we're not going to be sued by those people who agree with us. There is always a possibility of someone coming out from the left field and suing the district. I think that chance is going to be minimized with passing this resolution. This is a good resolution. It's going to put us in a good position to negotiate, to find a solution. And with that, Mr. President, I move for the board to adopt the resolution as it's been presented today. Call for a question.
Second motion. Roll call.
Director Chaperon?
No.
Director Holtman?
Yes?
Director Urigi?
Yes.
Director Hawkins?
I'm going to abstain.
Director Osuli?
Yes.
Director Vasquez? Director Camacho Rodriguez?
No.
President Apodaca?
Yes.
Motion does not pass.
What is the number?
You have 4 ayes, 2 noes, 1 abstain, 1 absent.
General Counsel's report.
Well, we have item 4, which is totally separate than this. Item 4 is totally separate than this, and it's a necessary thing that we do, especially in light of what we just did.
Another dogfight. Approval of water rate study.
Speak.
So, this item is a follow-up and cleanup of what the board, related board action on July 10th. I believe it was the intent of the board to approve the staff's published recommended motion on that day, which included the rate study approval of the resolution authorizing the meter charge. Number 3, approving the appropriate budget option. And number 4, approving the resolution authorizing the district's rate schedule. However, it appears the motion wasn't specifically stated that way. This motion is 100% consistent with the adopted budget, no changes to any of the dollar amounts. This item is just a belt and suspenders to verify the motion, the recommended motion from July 10th. And again, as that motion wasn't abundantly clear, staff is requesting the board formally adopt the 3 remaining items as a culmination of prior board discussions and staff presentations on these topics as follows. You'll see the recommended motion. Number 1, approving the water rate study. Number 2, approving the resolution establishing a retail meter charge. And number 3, the resolution for the water rates and charges. That concludes my presentation. I'll be happy to answer any questions.
So, Mr. President, just as a point of clarification, concerning the last discussion and the progress or lack of progress we're able to make with accepting the $2 meter charge as a board with the proposed resolution from the purveyors, is this being put at risk, or are we prepared to move forward with a minimum of the $2 charge as a board?
No, we're going forward with the $2 charge as a board. We have not precluded this resolution, there's been some requests. If you take the rhetoric of the last 2 hours and summarize it down, there was a request for more information and more process, so we can provide that over the next couple of weeks, hopefully have a, what was the, I believe Director Camacho Rodriguez, you had a term for it, a study session?
Yes.
We can do a study session on and bring the, but, so this is totally separate. This is just cleaning up or implementing our budget for this year, 1 year only.
Assuming and moving forward with the $2 charge.
Yes, it is a $2 charge.
Regardless of the resolution that was proposed by the purveyors and reviewed by the board, correct?
Yes, which is what we, which is,
Okay.
yeah.
Thank you.
Questions?
I was wondering, I don't have them yet, the difference in all the editing from the initial one that we heard in one of our committees for the Reftalis report to the one that's present. Myself personally, I would have liked to have seen the changes from the first presentation to today. And so I have not received those. And so...
I'm sorry, did you request that, ma'am?
I sure did.
Okay, and you have not got them?
No.
Okay, we just had one director request it that I know of because we provided it to her. So but as it is at the Reftalis report, the only edits that were in it were as we changed the rates.
All of the attachments on the July 10th meeting are in this with no revisions.
But anything prior to July 10th is what the director's asking.
So to kind of bridge a gap of information for me, so initially when we had the 24th, I believe it was on the 24th or the 10th, we had discussed the 461 rate, 468, I'm sorry.
Yeah.
And so there's a big gap of information missing for me from $2 to 468. And so for me, I understand that it's a math situation based on our budget, and so I understand that. We don't need to go through all of that. I just think that there were conversations that were had from either parties, so that we ended up from a 468 to accepting a $2. So I would have liked for those $2, $2.25, $2.50, going all the way to the 468, that there would have been some kind of continued record, so that we had it on record that was a discussion. I know myself that when it was pointed out that it was ridiculous to ask for 468, myself, having heard those numbers and reading them in a report, it wasn't ridiculous that we paid Mr. Reftalis a lot of money to put things on paper. So my concern is that there's a big gap from $2 to 468, and I understand that's related to our budget and things changed. That's understood. But we really, in good faith and effort and transparency, should have put that on paper so people can understand how we got from 468 to $2, especially when people are looking at us as negotiators. So as negotiators, we had options. And it was $2 at the low end, all the way to 468. So where do we have that on record and then showing the differences? That's just my opinion.
Okay, no, let me explain a little bit about it. It wasn't as a negotiation. Everything we do in a rate study has to have both cost and revenue to match it. As we decrease the cost, because when we're at 468, we had, first we did was the board approved $350,000 in personnel cuts. Then LIBOR came in and we had $171,000 LIBOR revenue. Then the board approved another $74,000 in cuts, and we also had another $234,000 in revenue that came in from increased water sales. You add that all together, that takes the 468 down to the $2. And you're right, we should have had a presentation clearly showing that. I thought we did it last board meeting, but we didn't.
So for myself moving forward, I would appreciate that on paper, because I think with oral reports and just people making comments about just throwing out numbers, and then it's not evidenced in paper that there's a history that we actually discussed that. And so I know as people are texting me, which is a good thing, about how when did we have this in public comment, I heard and I saw the video where your board member was told that, that was ridiculous to ask for 468. but then there's no record that we discussed $2 in an open comment, in an open session. So that part is super important to...
You're correct, and 468 was not ridiculous in the context of the budget we had there. Our revenue has to match the budget with whatever we need for our debt covenant ratio. So we don't pick them out of the air. As any time the request for the fixed charge dropped, it was because either increase revenue somewhere else or decrease cost. So you're totally correct. It was not ridiculous, and that type of language is always inflammatory and inappropriate.
And
So just to add, sorry, go ahead.
So I would just like to add, in good faith, and we're talking about working with our purveyors, that no one on our board has expressed not to want to do that. For myself, with where we're at today, with having adopted a budget and a rate charge, that as we enter documents that we're approving them, missing pieces of information does not make me feel comfortable when people question us. And they're valid questions of missing pieces of information. So our purveyors drafted up a resolution that they felt was very cohesive. Their attorney went ahead and, stamped its approval. And so when we look at how things are put on paper, I would like to feel that as a board that we are putting our stamp of approval with our vote, with everything present. And so...
For these motions, everything is present, ma'am. There's nothing missing.
Well, the $2 part is missing. So when I look at the document, and I read it multiple times looking, there's that portion missing. It's a gap.
Again, and this is an explanation maybe, but the rate study is a document that goes to the board justifying the rates. If you choose to reduce your rates and reduce your expenditures of the board, that's the board's prerogative. So the board reduces the expenses at the board meeting, which they did, then we have to reduce the rate. As long as we don't go above what's in the rate study, we're okay, protected legally. And the attorney's nodding here. So we don't revise the rate study to match the board actions afterwards, as long as it's reduced it. But I see your point, because in an ideal world, it would reflect, but that would preclude the board having the initiative and the responsibility to reduce costs or change rates. So that's what we did in this case. Our rate study was done with the proposal at that time, and right now you as a board choose to reduce it, and so we're okay legally to approve this rate study as long as we're lower than the rates that were proposed.
Mr. President, I'm sorry. Kevin, have you been ever involved with or know of a case where a rate study was prepared, went before a board or a governing body, and ultimately they decided not to adopt?
Oh, yeah, absolutely.
So the rate study is just a guide for the governing body to make a decision, to understand what their finances are, to understand what they have to charge their customers in order to basically make the ends meet.
This one's a little different. This one is a little different, and that is also the justification for the fixed charge. Let's put that on the table. So we need to adopt this because it's the underpinnings of what the cost allocation that was done and the methodology that was done for the fixed charge.
Right. But again, it acts as a guide.
Yeah, it's a guide, and within it, as long as you don't, and even the board's discretion, they could choose to go above it, but they have to have justification.
The 468 was based on the information that Rafael got from us about our finances.
Yes.
Figuring out what our needs are, what the shortcoming was, what was the gap between the delta between the income and expenditure. And we decided that perhaps because we're meeting the 26 thresholds, the best way to do it for the time being is a meter charge.
Yeah, we had an alternative which was all on rates. We went through that. So
then happened the decision by this board to reduce costs. Well, if you reduce costs, the 468 cannot remain 468.
No, you legally have no justification.
It has to be a different number lower than 468.
Yeah, unless you choose to increase your allocation of reserves, but the board did choose to do that.
So the number decreased, and you had presentations about that. Did you or did you not?
Yes.
I remember you talking about the calculations and showing us the numbers and how we arrived at the $2, right?
Absolutely. So just to can I add a comment here is that staff anticipated your question, Director Camacho Rodriguez, and so we emailed this sheet. If you may, I'll bring it up for you.
That's a recapture of the board actions that led us to today's.
Yeah, he mailed it
I
out
saw that.
yesterday. Yeah. Well, there's a lot going on with it.
Yes, so in that, it has, number one, the board considered, actually the committee, on May 8th, a $4.68 meter charge and a $249 per acre foot administrative surcharge. For number two on this list, that item plus the first revision, I'll just call it proposal number 2, was proposed at the May 28th board meeting. That was a $3.61 meter charge and $190 per acre foot. And there were approximately 5 different revisions to expenses in that proposal. If you like, for the whole board, I can continue through this, or I'll continue. The first was elimination of the merit pool and staff furloughs, 1 day a month. That would have been a $194,000 reduction. Capital spending was reduced by $275,000. About $100,000 for technical assistance from consultants was proposed. OPEB funding of approximately $34,000 was eliminated, and there were memberships reduced by $55,000.
So Andrew, I just want to make sure, this is the document that you're reading from, the one that I have, that I received from you, same document?
Yes, number 1 through 6.
Right. And, so I just want to reiterate that this document clearly, Director Camacho Rodriguez, you were concerned about the transparency and all that. This essentially traces back.
I asked for this. That's why we created it.
Right, I understand, but I'm saying this document then recaptures what you were trying to do.
Exactly,
Which is set the trace for what has happened, the kind of actions by this board. So if anyone questions it, you and I can go and say,
Right.
these were the actions that were taken, right?
Right. So this was a necessary document. Thank you.
So I guess my next question is, do we have the information that we need? Or are there any other questions for Andrew?
Move recommended action. Second.
Second.
Director Chacon? Director Heldman?
Yes.
Director Arrighi?
Yes.
Director Hawkins?
Yes.
Director Schooley?
Yes.
Director Vasquez? Director Camacho Rodriguez?
Yes.
President Apodaca?
Yes.
Motion passes.
General Counsel report?
I don't have anything to report today.
I have a GM report. The directors, just to put you on notice, that the week of August 12th, we'll be trying to set up a special meeting to do interviews for general counsel. You're from sure.
Is that it?
That's it, sir.
Okay. Director Hillman, do you have any comment?
Just that I met with Chairwoman Gray from Metropolitan yesterday in her office right around 2 o'clock and had a nice discussion about the wonderful progress we're making here at Central Basin.
Director Rodriguez?
Nothing to report.
Director Skewy?
Nothing, sir, thank you.
Director?
Nothing.
Or no? No. And I have nothing to say. He's adjourned.